Mr. Don Deya from the Pan-Africa Lawyers Union, thank you very much for joining us for this interview. Now, what is the African Union's current approach to addressing international crimes on the continent?
The formal policy of the African Union, or the AU on that matter, sometimes it is forgotten. The formal AU policy is that there should be robust investigations and prosecutions for mass atrocity crimes and for serious crimes, and this should be done on the continent. The only problem that at some point in the past the AU had, or some member states of the AU had, with international criminal justice was its selective, or what they perceived as its selective application in international courts and tribunals and universal jurisdiction in Europe. So they resolved that African countries should strengthen their legal and policy frameworks and strengthen their institutions to be able to prosecute and investigate crimes all across the continent. And in addition to that, they did adopt the Malabo Protocol, which we'll talk about later, which was to create some sort of African super ICC, an African court that would have international criminal jurisdictions over the core mass atrocity crimes, which is genocide, war crimes, crimes against humanity, but also over other crimes, corruption, money laundering, human trafficking, trafficking in hazardous wastes, and so on. So they don't always implement their policy robustly, but the formal policy is strong.
Critical voices say that one has to give teeth to the existing AU human rights instruments to make them truly efficient. What do you say about this criticism?
I think sometimes the problem is what I call over-lawyerization, that to a person with a problem, with a hammer, every problem is a nail. The African human rights system currently has the African Court on Human and People's Rights in Arusha, the African Commission on Human and People's Rights in Banjul, the Gambia, the African Child Rights Committee in Maseru, Lesotho, and it also has the Political Affairs, Peace and Security in Addis. I believe that the powers that they are given by the various legal instruments that establish them is enough. There can always be improvement, but what we have is enough. So what we need to see is more robust implementation of what exists. And examples exist in the past when we've seen these same institutions that I've listed being much more robust in trying to make interventions, especially when there's a threat of serious crimes being committed or when mass atrocities have started. So teeth is needed in the sense that first, implement more robustly what you have. And the major challenge that many of them face, apart from some sense of not being brave enough, is how much resources they are given. Human resources, technical resources, financial resources, budgets. So this is where the people of Africa need to hold their governments to account and say, are you giving these institutions enough money, enough human beings, enough personnel to do a good job?
How does the African Union collaborate with or complement the International Criminal Court's work when it comes to prosecuting international crimes in Africa? And are there efforts to strengthen African solutions to these issues?
The first question is, from around 2009, and the peak of it was, I think, around 2014, when we had the trials of the then Kenyan President Uhuru Kenyatta and his then deputy William Ruto, who's currently president. Between that period, there was a cooling of relations between the AU and the ICC. 12 years earlier, when the Rome Statute negotiations were being undertaken, African states and the AU, or the OAU as it then was, were amongst the strongest supporters of a strong international legal order with the court to handle mass atrocity crimes, because we had been the victims of the most horrific crimes. So there'd been a period when they cooled, when some actors, political actors and other actors, felt that the ICC was selectively targeting only African senior officials and not others. So there's not been as much collaboration as there should be, and I think there should be. But with the African people, the CSOs, the academics, the scholars, the trust, the think tanks and so on, there's been very robust collaboration and cooperation, both in situation countries, but also around just building a stronger international legal order. And of that, I'm very happy.
The Malabo Protocol extends the jurisdiction of the African Court of Justice and Human Rights to try international crimes. What is the current status of the protocol, And how soon could we see it becoming operational in trying these crimes on the continent?
We could be ambitious and see it get operational in the next 5 years. What happened is when eventually the legal instrument, the protocol establishing the court, was adopted at 2014, as I said, it was at the height of this discordance in opinion between the Africans, or the African heads of state, the African political leadership, and the European leadership around international criminal justice and around the ICC. So very unfortunately, and I don't blame them, very unfortunately, many Africans who are watching saw the Malabo Protocol as an attempt by African leaders to run away from justice. So there was very serious opposition amongst the people to the Malabo Protocol. So I think it took a lot of time and things calming down and people cooling off to then do a cost-benefit analysis of the Malabo Protocol, and then for African people to begin saying they saw more good than bad in it. So it's just in the last 12 months that we have received the first ratification, and that's from the Republic of Angola. And the Pan-African Lawyers Union is part of the Coalition for an Effective African Court, which supports the court in its current iteration. And we've been jointly now been running a campaign over the last 3 years around ratification. Actually, it is largely because of that campaign that we got our first ratification. So we're working under the umbrella of the campaign, expanding it, bringing in more allies, both among the citizens and among the member state officials, towards more ratification. For it to come into force, we need 14 more. And I think that now that the first one has gone through, the momentum will begin picking up. Within the next 5 years, we might see ourselves arriving at 15 and begin practical establishment of the Malabo Court.
Can you provide examples of ongoing or past strategic litigation cases tried in African regional courts or accountability mechanisms?
One prominent one that we're currently engaged on is in the African Commission on Human People's Rights concerning the violence that happened in Tigray between 2020. I mean, it's ongoing, but the peak was between 2020 and 2022. So at the height of it, the Pan-African Lawyers Union, together with Legal Action Worldwide and with some pro bono support from some law firm, actually launched a case at their complaint, a communication at the African Commission, that the government is bound to protect all its citizens, including those from the Tigray region. And we applied for provisional measures. And 7 months later, we actually did get provisional measures. And 3 or so weeks later is when the government and the TPLF signed a cessation of hostilities. So we believe that this idea that there was a provisional measures order from a credible African Union institution was part of what motivated the actors to move towards a cessation of hostilities. So that is one. We've done a couple of other cases involving the situation in South Sudan. We've gone after violations undertaken by the security sector, extraordinary illegal abductions from neighboring states, extraordinary renditions into Juba, arbitrary detentions in ungazetted facilities. Basically, the National Intelligence Service runs a huge illegal prison. So we've targeted this and we've engaged in serious naming and shaming of senior officials as part of transitional justice for the people of Sudan. And when these cases conclude on their merits, we are sure as part of the measures the court will order will be guarantees on non-repetition, which then will be useful tools to fight for the transformation of our various countries.
Which forum was this case tried at?
This was at the East African Court of Justice.
Does the handling of these cases give you hope for a more robust system to try international crimes on the continent?
Yes, they give a lot of hope. First, applying the full spectrum of transitional justice, they are an opportunity. They give the communities that we represent a right to be heard. They give them their day in court, which is satisfaction. Then they give an opportunity for documentation, authentic, properly evaluated documentation. And then they give opportunities for guarantees of non-repetition. And many times with these trials, we actually try, even though it's a trial for state responsibility, we actually try and name and give as much detail as possible of the perpetrators to increase the chance, for instance, that the court while giving its decision on state responsibility, can specifically recommend that certain individuals be investigated or prosecuted or sanctioned. So the court, in principle, can actually make, any court in Africa, in principle, can actually make a referral to the ICC, for instance, and says, we found state X to have violated the rights of its citizens during the crisis, and these particular individuals ought to be investigated with a view to prosecution.
Mr. Don Deya, thank you very much for taking the time to join us for this interview. We are very, very grateful.